5 seconds to go. Start. Learned advocate for the opposite party number 3 and 4, comma, learned senior advocate appearing for the opposite party number 5 and 6, comma, learned advocate appearing for the opposite party numbers 2, comma, 7 and 8, opposed the contentions of Mr. Bhattacharya and submitted that the police officers have been malafidely implicated in the present case only on public perception and there were no materials to frame charge against them, comma, however, comma, the learned trial court has framed charge which calls for interference. Stop. Learned advocates also prayed for discharge on the ground of sanction, which is a subject matter of a separate revisional application. Stop. Para. In Gauri Shankar Sharma versus State of UP, reported in 1990 Supplementary SCC 656, it has been observed as follows: colon para. The offence is of a serious nature, aggravated by the fact that it was committed by a person who is supposed to protect the citizens and not misuse his uniform and authority to brutally assault them while in his custody. Stop. Death in police custody must be seriously viewed, for otherwise we will help take a stride in the direction of police Raj. Stop. It must be curbed with a heavy hand. Stop. The punishment should be such as would deter others from indulging in such behavior. Stop. There can be no room for leniency. Stop. Para. The Honorable Supreme Court dealt with facts of torture and custodial death and arrived at a finding that tolerance of police atrocities would amount to acceptance of systematic subversion and erosion of rule of law. Stop. The following paragraphs are relevant for the purpose of the present of case, comma, which are set out as follows: colon para. In addition to the protection provided under the Constitution, comma, the Protection of Human Rights Act, comma, 1993, comma, also provides for protection of all rights to every individual. Stop. It inhibits illegal detention. Stop. Torture and custodial death have always been condemned by the courts in this country. Stop. In its 113th report, comma, the Law Commission of India recommended the amendment to the Evidence Act, comma, 1872, hereinafter called the Evidence Act, comma, to provide that in case of custodial injuries, comma, if there is evidence, comma, the court may presume that injury was caused by the police having the custody of that person during that period. Stop. Onus to prove the contrary is on the police authorities. Stop. Law requires for adoption of a realistic approach rather than narrow technical approach in cases of custodial crimes. Stop. Para. We are deeply disturbed by the diabolical recurrence of police torture, resulting in a terrible scare in the minds of common citizens that their lives and liberty are under a new peril when the guardians of the law gore human rights to that. Stop. The vulnerability of human rights assumes a traumatic, comma, torturesome poignancy when the violent violation is perpetrated by the police arm of the state, whose function is to protect the citizen and not to commit gruesome offences against them, as has happened in this case. Stop. Police lockup, if reports in newspapers have a streak of credence, comma, are becoming more and more awesome cells. Stop. This development is disastrous to our human rights awareness and humanist constitutional order. Stop.